Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Welcome to another episode of Empowering Plans. Today you have myself, Kelly Dempsey, joined by Kevin Brady. So hopefully two of your favorite podcast hosts. We are recording this on Valentine's Day, so we can unleash any of the witty banter and maybe a good dad joke that Kevin has. I don't know if he's got one warmed up yet.
No, I don't have anything good, but my favorite Valentine's Day card was just I hope your day is dynamite, and it just has a big picture of a dinosaur. I know, you probably have to see it.
All right. Yeah. Well, anyway, so today our topic is not really Valentine's Day related. I mean, you might be able to draw some connections in the back of your mind, but I'm going to try to stay on task and focused and not get off track talking about that. But today we're going to talk about the ADA, reasonable accommodations, and some potential changes that are now coming and related to the Pregnant Workers Fairness Act. So we get another new acronym, the PWFA. Doesn't really roll off the tongue very well, but it's the PWFA, the Pregnant Workers Fairness Act, which has made some changes regarding how we apply the ADA in pregnancy situations. So I know you might be thinking, why is this relevant? This has nothing to do with health plan. This is more of an employer issue. You're not wrong. The ADA is generally more of an employer-related law that you have to look at. However, the ADA does talk about reasonable accommodations, and one of those accommodations might be a leave of absence. And that's where we start crossing over into potential health plan issues if the leave of absence, as designed by the plan document, also includes a continuation of coverage. So there's your connection to the health plans and how we go about this. I know that we have talked about leaves of absence and continuation of coverage in the past. It's one of my favorite things to talk about because there's always been some misconceptions related to the ADA. The ADA doesn't actually require a continuation of coverage when they offer a reasonable accommodation, which may be a leave of absence. But employers can do that as long as they document correctly and put it in their handbooks and put it in their plan documents and show that. So with that, the moral of the story when it comes to the ADA specifically is that it contemplates a good faith interactive dialogue between employers and employees. And I know that this is the typical lawyer statement about, it depends and it's a case-by-case basis, but the ADA is one of those laws that is particularly relevant to that concept. It's always going to be a case-by-case basis. You're not going to be able to have, a broad rule or application of when a leave of absence is a reasonable accommodation. It's going to have to be looked at on a case-by-case situation, fact pattern by fact pattern, person by person, however, any other ways I could think of to say it. But the most important piece is that interactive process. So that was a pretty long-winded introduction, and I apologize. So I'm going to turn it over to Kevin to talk a little bit, give us a little bit of intro about the ADA and the PWFA. I'm never going to get used to saying that, but I'm going to try to kind of tee it up, and then we'll go through the process of how to determine when a leave is a reasonable accommodation. So Kevin, why don't you take it over?
Yeah, of course. Yeah, thanks. We always talk about this, but the acronyms, there's never enough of them, and they never seem to really roll off the tongue as well as you'd like them to. But yeah, so, generally under the ADA and the now going to be effective in June, PWFA, essentially an employer is required to make a reasonable accommodation for a disabled employee, or in the case of a PWFA, basically, a worker with no limitations due to a pregnancy, childbirth, anything like that. And they're required to make those reasonable accommodations as long as there's no, that's not going to cause undue hardship on the employer or anything like that. And that comes in a few different ways, right? So those reasonable accommodations can come in the form of, making the existing facilities readily accessible. So think about ramps or anything like that. And then also would be, modifications or adjustments to the employee's job. So that could include job restructuring, part-time, modified work schedules, reassigning to, other positions, anything like that. And then a big one would be, potentially a leave of absence if it's going to be the best option for that employee too. And thinking about kind of the difference between the ADA and the PWFA, one of the expansions here is to kind of remove the term disability or, making that kind of the distinction, but rather looking at the specific instance for that individual, whether it be thinking about pregnancy, childbirth, or any kind of related medical conditions that have to do with childbirth. So the expansion here is, like I said, removing that level of disability, which is going to be common under the ADA or required under the ADA, and really expanding that to a number of different people that it could be applicable for. That's going to be one of the big expansions there. There are a couple of other ways that the PWFA expands the ADA and kind of the way that employers are required to treat and deal with those kind of situations. That's going to be the biggest one for our purposes. And I think really the important thing that we want to take away here is, what the process actually looks like. What are the interactive, good faith communications, conversations going on between the employee and the employer? And I'm going to throw it over to Kelly to talk through that a little bit more.
Sure. One of my favorite things. So as an attorney and somebody who's maybe a little type A, I like things broken out into steps and processes. And I'm going to go over these very quickly because there are quite a few of them. But one of the questions we get asked about is relating to reasonable accommodations and what does that process look like to come up with an accommodation. So the first step is deciding, to look at the fact that, again, it has to be a good faith interactive process between the employer and the employee. So a solution must be agreed upon to accommodate that disability or pregnancy. So again, like Kevin said, that's where the ADA kind of differs, is the ADA did not originally consider a pregnancy to be a disability unless there was a complication related to that pregnancy. So that's the change here that happened from the ADA and why a leave might be a reasonable accommodation under the PWFA. So first off is having that interactive dialogue about figuring out what the issue is the employee is experiencing and what the accommodation process is going to look like for them. So it's really just that disclosure of the disability or pregnancy in some cases, that employers are really under the ADA are only required to accommodate disabilities of which they are aware. So that disclosure is kind of step one. Step two then moves to determining if an employee under the ADA is determining if the employee is qualified. So, this step might not be as complicated for the PWFA, but we're going to focus on specifically the ADA, what their process looks like. So the employer has to review the request, determine if there's additional documentation that's needed. So if there's documentation from a medical provider, in some cases, they might need a written medical release in order, obviously, to gain access to that information. But then they're going to have to review the details. They're going to have to review all that documentation and determine the nature of the impairment, the severity, the potential duration as to how long this disability is going to last, because not all disabilities are permanent. Some of them are temporary. It's going to have to consider the activities that might be limited by the impairment and, again, how that impacts the essential job functions. So that is a crucial part to this that we're not going to go too much in depth because we're obviously focused on the leaves piece and that kind of conversation right now. But the essential job functions is an important piece to determining when and what the accommodations are. So because the issue, the disability or the pregnancy would have to be impacting those essential job functions. All right, so step three in the process is to have that interactive process, establish that there needs to be an ongoing line of communication, that the employee, if the employer asks for something, the employee needs to give it back, and so on and so forth, that there has to be that continuous dialogue. And again, if the employer has to obtain any sort of verification from a medical provider, that part of it is also part of this. This could look different based on the type of an employer and then based on the type of employee. So for example, if you're in a manufacturing plant versus a place where you're delivering stuff, so it's truck drivers or bus drivers, maybe school, whatever that case may be, or if they're in an office building. So the different types of workers, if you have somebody that's on their feet all day versus somebody that's in an office building and sitting behind a desk all day versus somebody sitting in a truck, all those processes are going to look different for every employer and based on the job duties, because it's just the nature of the beast, unfortunately. Again, like I said, the point of this is if the employer stops communicating at any point in time, their chances are they're going to lose. These processes are very deferential to the employee, so that's something important to remember for employers. Again, summary of step three, the employer has to establish what a process looks like for them, what that interactive process is. And it's going to look different for every employer. This isn't a situation where you can copy and paste a policy off of the internet. I'm sorry, don't hate me for saying that. But this is one of those situations where you're going to have to, again, figure out what that process looks like based on your different employees and establish what that process is. So step four is the maintenance of records. Pretty intuitive. that you got to document the process, keep all your records, and it should be separate from the employee's personnel file. Just keep that in mind. It shouldn't be part of the same file because they're two different issues. The employment issue as well as, contemplating a disability and an accommodation for a disability are two different things. So you're going to want to have a full timeline of events, dates, when things were requested, the dates that conversations happen, when actions are taken, when verifications were received. And then, if there's additional evaluation that has to happen to make sure that things aren't getting worse, that those changes that you've made aren't worsening the disability or the stressors that the employee is dealing with. So again, that's an important piece to that. It's maintaining the records of the process and effectively papering your file. That's the moral of the story. So step 5 goes to what is the accommodation is best. Kevin kind of alluded to this and talked about it, but what is a reasonable accommodation can look different. It can be job restructuring. It can be a leave of absence. It can be modified work schedule to part-time or something to that effect. It could be a reassignment to a different vacant position. It could be modifications to the actual workplace. And again, all of these take into consideration what Kevin said. It can't be something that's unduly burdensome and creates undue hardship on the employer. So it can't be excessively burdensome or have a high financial cost to it. And that may depend from the different types of employer. So for example, in removing a truck driver from a driving position probably isn't going to be a reasonable accommodation because that's literally the essential function of their job. But then you also have, a nonprofit that has some people working at, desk jobs, typing, grants or whatever the case may be. And the accommodation that the employee is asking for is some sort of special chair for the employee. If the employer is a small nonprofit, maybe that's overly burdensome to them from a financial perspective. Whereas if it's a large for-profit corporation, they wouldn't have a problem with that. It wouldn't be a financial burden. So again, it's going to also consider what's burdensome to the employer as well as what's going to benefit the employee. So that's something important to consider. So determining the type of accommodation is step 5, always going to be a case-by-case basis. And then that step 6 is looking at the potential alternatives to that accommodation, because an accommodation must be reasonable and not create the undue hardships on the employer. So kind of combine steps 5 and 6 really there. Sorry about that. But that's kind of what we're looking at from this perspective, is that it's got to be something that is going to help the employee. It's not going to be burdensome. One thing that's important to consider is that it's not an accommodation if you need to provide some sort of personal use item to the employee. So if they need a prosthetic limb or a wheelchair, or eyeglasses, hearing aids, those types of things are things that the individual is going to need on a regular basis and not just at work. So it's not reasonable for an employer to have to provide that. Other things that are not considered reasonable is removing or eliminating an essential function of the job and lowering production standards if that's part of the job already. So again, maybe that's something that comes into play in a manufacturing plant and not, at a desk job, but maybe it could, just depends. So that's something to consider. Step 7 kind of goes to the notification process. Once you figure out what that accommodation is going to be, you got to notify the employee of what's happening next. So what the decision is. And then again, there's a continuous review. It needs to be continuously monitored to review the employee's disability and the employer's business needs. So it's one of those things that's, again, it's a continuous process. It's not something that really has a clear start and stop date until that disability has resolved itself. So I know that this is going to be a longer podcast than Kevin and I normally do, but I apologize. This is a pretty meaty topic, but I thought it was important with these new laws that are coming into play. And we wanted to kind of talk through that process and then determine, again, talk through as this law comes into play, how these processes apply to the PWFA and things to consider once June rolls around. So with that, I'll turn it over to Kevin to talk about that leave of absence piece in a little more detail.
Yeah, of course. So, one thing to think about and how we're going to kind of tie this back to, health benefits. And, that's really obviously the world that we live in every day here at FIA. So what happens if there's, a reduction in hours or a leave of absence that happens to be the reasonable accommodation under the ADA or the PWFA? And, the answer is that it really does depend. But looking at those laws in particular, if you look at the ADA or the PWFA, there's no specific, requirement to continue health coverage during a leave of absence. So at that point, you really do have to look at the plan design in particular. So in that situation, if there is a leave of absence, you have to look at what the plan says, look at the plan design. And most of the time, an individual is not going to meet that requirement to be actively at work, working a certain number of hours to be considered eligible, all of that stuff. So you're going to need to look at the continuation of coverage provisions there and determine whether or not health coverage is going to be continued for those individuals. And like we said, it's not required, but oftentimes that may be the case, whether that's under a general leave of absence or even ADA specific leave of absence kind of provision in the plan document itself. So anytime that you do run into that situation where there is potentially a leave of absence, you're going to want to outline that in the continuation of coverage section and make sure that not only is that language there to provide that continuation of coverage, but also to put a duration on it too, because you don't want to have it just kind of in perpetuity. Then you might run into, a situation where it's kind of hard to fall back on it or rely on that in any way when you're thinking about how long that kind of continuation could go on. The other thing to consider is that sometimes these things can also fall under the FMLA category too. So there could be situations where someone might have their own rights under FMLA when it comes to continuation of coverage, and whether that be intermittent FMLA, a regular FMLA leave, whatever it might be. It's just really always important to consider what laws are implicated here. Are we talking about ADA leave? Are we talking about FMLA? Or are we talking about even a leave of absence at all? I mean, that doesn't necessarily mean that the reasonable accommodation would be a leave. It's just important to outline that in the document if that is the case. The other thing to think about is not necessarily a leave of absence, but potentially a reduction in hours. And the big thing that pops out here is just to consider the employer mandate, that the employer mandate's kind of always in the background there. So if the group is subject to the employer mandate and they happen to be using the look back measurement method, then it is possible that you can't just necessarily change that person's, eligibility for coverage due to the fact that they could be in a stability period or whatever it might be. So it's always important to kind of consider, not just in the leave of absence space, but also if there's a reduction of hours, that there's going to be other things going on, whether that be, like I said, the employer mandate, FMLA, or all those different things. One other thing that we just wanted to mention here before we wrap this up, we are talking about the ADA and the PWFA in particular, but there are a lot of states that have enacted their own laws that, may already kind of require certain accommodations for pregnant employees, for childbirth, or whatever it might be. So it's always important to think about state law as it relates to that. So it's interesting to look at it too, because before the PWFA came out, this is still the case, but there are a number of states that don't really address this at all. So I think there's 5 states that don't have any laws prohibiting discrimination on the basis of pregnancy. And I think there's 6 that prohibit discrimination, but they don't mention anything regarding any type of accommodations at the workplace, anything like that. So it is important to think about state law and what the state says. So that's really going to be important if the state has more generous leave requirements or more generous reasonable accommodation requirements, continuation of coverage, whatever it might be. It's always important to check what the state law says to make sure that the employer's practices are going to be consistent with those state laws. So with that, on this great Valentine's Day, I'll throw it back to Kelly to kind of wrap things up and put a nice little bow on it so we can give it as a Valentine's Day present.
Oh, Kevin, I think you're the Triceratops.
That was good. Did you look that up?
No, I did not. I totally had that available.
Wow, people are going to think we planned the dinosaur jokes. I promise we didn't.
I may or may not have watched Jurassic World last night, so that might have played into where my brain went when I was thinking about dinosaurs. You brought it up first. Anyway, so we'll summarize everything. So this can definitely be a confusing topic. When it comes to the ADA, the original discussion or related to the ADA is that it is employer-based law the employers have to be conscious of in many aspects. And we very much narrowed in on kind of one piece of it. But it is that concept of the non-discrimination related to disabilities and accommodating those disabilities up until the point where it potentially becomes burdensome to the employer from a financial perspective, or if it's just what they consider some sort of undue hardship related to extensiveness, meaning that it's something over and beyond. But the ADA requires employers to accommodate disabilities, and one of those accommodations could potentially be a leave of absence. What the PWFA is going into effect in June, it was passed at the end of 2022, and it, again, like Kevin said, it kind of takes out that disability requirement, but it expands the protections, the ADA-like protections related to leave of absence and accommodations to pregnant individuals, because pregnancy was not considered a disability unless there was some sort of complication. So now that's removed. Somebody doesn't have to have a complication related to a pregnancy in order to have some sort of accommodation in their workplace. So this is new, the ever evolving landscape when it comes to leaves of absence and continuations of coverage and paid leave. Kevin and I have talked about this stuff before. So it's definitely an evolving landscape that employers need to be aware of, because it's going to continue to change. This isn't going to be the last time we talk about leaves and continuation of coverage and all of these fun things. The landscape is going to keep evolving. If you listened to the State of the Union, there was kind of some, discussion related to, again, more employee protective laws that are coming into play regarding paid leaves and things of that nature. So this is where we're going. This is one of the reasons why we're talking about it, and we'll keep talking about it because it's going to keep evolving. Employers need to make sure that their documents are synchronized. That's something that, we'll say till we're blue in the face because it's very important. A lot of our document reviews talk about that synchronization of documents. So that's one thing that we can kind of help with when it comes to this, is that synchronization of handbooks to plan documents. If you need help with that, that is something that we also offer. So just keeping that in mind. But, the ADA needs to be a good faith interactive process. It needs to be an open line of discussion, which, is also going to spill over to the PWFA as well. So hopefully this was helpful. Again, very, very loose, tying into the Valentine's Day concept. Use your imagination there. But thank you so much for listening. And sorry, this one was a little bit longer than normal, but hopefully it was helpful information.
Valentine's Day treat for all.
Have a great day.